My goal is to kind of go through this presentation, which if you've sat through either the event that we run with Peg McCormick and the Federal Bar Association in Chicago, you will have seen parts of this. If you've had the misfortune of hearing my other lectures on I-9, some of these slides will seem familiar. Forgive me. I'll try to end to allow some questions by about 1:30 or so, maybe even a little bit before that. I won't go too fast. Sorry. We're fast talking here at Stanford. You get longer minutes, more words per minute. I'll try to slow down. Okay, so I named this Attention Shareholders as a little bit of a tongue-in-cheek joke because there really haven't been that many situations in which I-9 compliance comes to the attention of shareholders, the board, or even reaches the level of being a securities violation. But I could have said the exact same thing in the year 2000 about FCPA. And FCPA since that time has accrued hundreds of incidents, consumed billions of dollars of compliance effort, and accrued hundreds of millions of dollars of fines. And it had been around for a long time, which I'll talk about. I'm not sure if, in fact, I-9 compliance will reach that level. But the fact that we have a Senate bill proposed and we have a very strong focus on this compromise around securing the borders and then parentheses, not hanging out those mixed message signs that Representative Lofgren talked about, and the idea of trying to get this comprehensive immigration reform all together in one package, I think that's going to draw attention to and cast a spotlight on this issue. And FCPA was prompted by a series of similar issues which finally gave it traction and made it move forward. So I think we're entering a zone in which it's more likely than not, though far from certain, that we will see more attention to these issues. So I said attention shareholders because shareholders in this story, particularly for publicly traded companies, have a lot to lose if companies have significant problems with I-9 compliance. And in theory, they've already lost a lot on paper. It's just that no one's called anyone on it. And we kind of hope that they don't. But on the off chance that they do, we want to ask, what can you do? So here's the exciting graph from BLS Data, April 2013, only a few days ago. It hasn't yet been fully compiled, but it is valid. The kind of gray area is the recession as officially declared by the Bureau of Labor Statistics. And this number is simply the number of unemployed persons per job opening seasonally adjusted, right? And I simply want to highlight something that is going to be a little bit counterintuitive. And the point is going to be that as the economy picks up, I-9 compliance gets harder, much harder, and I'll explain why. But as you can see, the number of unemployed persons per job opening just skyrocketed during the recession. This is obvious, we all knew this, but maybe you didn't quite know how dramatic that increase really was. And it was, of course, for two reasons. One, people were being laid off, and also number of job openings went way down. Those are actually separate factors that don't always move in tandem, and I'm going to explain why we care about the direction that they're moving. The good news, whether or not we're feeling it fully, is that we're headed in the other direction pretty consistently. It's bumpy, right? And weirdly, it gets bumpier in late spring. We're entering a phase where we're not sure we're going to see that kind of strong employment growth, but nonetheless, the trend is clear. But here's something that you've probably never seen, and unless you're really enamored with detailed Bureau of Labor Statistics numbers, and particularly their subset called the JOLTS data, which I'll explain in a few minutes, you won't have seen this. But I kind of joke that in any economy, if the green wire and the blue wire, they're lines, I know, but I thought it was funnier if it was a wire, touch, then bad things happen. Let me tease out this graph for you and point to the fact that weirdly, we are headed in a direction that if we don't really have good comprehensive immigration reform, if we don't take steps to solve some of the labor constraints within our economy, we're going to hurt ourselves terribly. As a side note, but the main point for this talk, the issues of I-9 compliance during a period of time where these two lines are getting closer and closer together gets harder, and I'll kind of go through all the reasons. But here's what those lines represent. So first of all, the red line is what we call the volunteer quits. These are the number of people that's thousands, so that's 1 million, 2 million, 3 million, 4 million along that axis. So these are the number of people each month who voluntarily leave their job. They're not laid off and they're not fired, they quit, right? To go to a different job, maybe to take 6 months off, to go to school. They leave their job voluntarily. The quits plummeted during the recession. Anybody know why? What do you think? Okay, boy, this room is bad. Right, okay, so I think you all said the same thing. Because you're like, I still have a job, thank goodness, right? And you hang on to it very, very tightly during the very scary recession where your neighbor gets laid off and your cousin gets laid off and your husband ends up with fewer hours. So that's one of the reasons voluntary quits go way down during recessions, because you're afraid. Okay, what's very interesting is that the time of the end of the recession, so first of all, that line dropped faster and more dramatically than it has in most recessions. It lasted longer on its way down than it has in any recession. And intriguingly, it didn't spike up immediately. This is very unusual that we have this kind of slow little trickle of increase where the voluntary quits haven't gone up a lot. Because what happens is you have a job, but a lot of people aren't happy with their job, right? Or they can upgrade because their skills are getting better. They're enhancing their experience. And or they worry about the stability of the firm that they're in. They have a job, but they're not sure if they'll have a job forever. So they quit. People were so traumatized and so afraid during the recession that they have still not really started to turn over. We estimate, and I'll get to this, there's a lot of pent up, what we call unrealized quits in the economy, and it's going to have a huge impact. So that's an interesting line, the red line. The green line is number of job openings. So that one we kind of knew, right, as we followed the economy. Boom, job openings just crash. I mean, it's a stunning crash. And then they go up slowly but surely, and they're on their way up. So those job openings, that's actually, it was a slow start, but it's starting to accelerate. It's not a great picture, but it's a pretty good picture. The blue line. What is the blue line? The blue line is the number of successful hires in that given month. So how many people who were looking for a job, notice that the job seekers are not on this. This is not an unemployment graph. That data is really hard to understand. It's relatively unreliable. This stuff is pretty reliable by comparison. But so the blue line is the number of people who successfully found a job and were hired. So this is from the viewpoint of the employer. So what's the problem with the blue line and the green line getting so close? Well, if the blue line and the green line swapped places or touched, it implies that we are creating job openings faster than we are hiring people. And that compounds the fact that we already have lots and lots of job openings and I don't have the slide up that I won't show it to you, but in this, we'll post this. You can go dig deep into the links if you like. There's a separate analysis that says how long certain job openings have been open. So unexpectedly, unless you've been following this data, lots of jobs have been open longer than in the past. What does this mean? It means the skill sets for those particular jobs aren't available in the labor pool. Those people might be hanging on to their current job because they're just nervous, right? And so they're not moving around, or they just might not be available at all. That discussion goes down a path where you can really argue at a pure economic level for comprehensive immigration reform. So I'm not going to go there, though I'm happy to answer questions a little bit about that. But if that green line hits the blue line, it means you will be paying for a professional position 20 grand to a headhunter. It means you will pay whatever amount of money you need to temp agencies to place people. It means you will start figuring out how to open all of your new stuff overseas. If those two lines touch each other, it's a disaster for the economy. You won't be able to find people to fill jobs. You will be getting orders from your business units, if you run HR, that create all these positions, and you're like, I haven't even started to fill the last 7,000 that you ordered in the last quarter. I mean, it will be unlike most anything that we've experienced, except in a couple of periods that had, dare I say it, significant wage inflation. Because the thing that you will then do is right now, look left, look right. If you see a fellow HR professional, be aware in 6 months you might not be talking to each other, because what you're going to be doing is you're going to be calling their employees up and saying, $30,000 signing bonus, 40% premium on your salary. Come over now, I have to have an answer today. And it's just going to get really ugly. We see this in little micro spots of the economy already in certain tech bursts, right? Certain tech skill sets have kind of always been like that, but if you've been following Silicon Valley, it's a little bit of an echo of what might, or foreshadowing what might happen. So this is the backdrop. Why do we care? Because I-9 compliance gets hard if you end up with a lot more to do as an HR professional. Right? No one's going to say, oh, I understand. There's all that compliance stuff you have to do, that paperwork. You know what? Take your time on that job order. No problem. Oh, need more budget for legal? Sure, no problem. Oh, need to reduce the number of people you send out to college campuses to interview and hire? Yeah, we can divert that to whatever it is you said you're doing, that audit thing in-house. Sure, no problem, right? That just doesn't happen. It goes the opposite way. So first, time pressure increases for the pacing of hires. What do we know happens when you hire people in a hurry? Parts of the HR onboarding process break. What part breaks and no one notices at first? Oh, it's the I-9, actually, right? We are the ugly, redheaded stepchild of the onboarding process. No one seems to care if you blow the I-9 because no one shows up that day to yell at you, or that week, or that month, but they might in the future be showing up on the quarter, and they'll be named Rob, right? They'll be the auditor, and there'll be issues. So that's the first reason. Second thing is the relative available workforce declines, and if you're already in a competitive space, it declines even more. And so that Canadian with that master's advanced degree, what's weird is you end up with what we kind of refer to politely as white-collar unauthorized employment. So suddenly you're employing people who you knowingly know are not authorized, and it's been a long time since we've been in that zone. But when you are confronted with a demand, hopefully you won't do this, but I fear a colleague or someone under you will be pressured to do it. They say, listen, I'm sure we can catch that stuff up later. I hear there's this reform bill going to make this guy legal anyway. Let's just move ahead. He's head of sales for Canada. I need him here today. I'm sure you've never heard anything like that phrase at all. Incremental accrued liability seems like a low priority. Little things, like why don't we all exercise more? Why is it that we have the second glasses of wine? Why did I eat so much cheese at the dinner last night? It's because you don't feel the pain right then and there. It's just a little itty-bitty bad thing that you'll pay for later. That's the story of I-9s. Those things fall to the bottom of the list. And here's the really interesting part, which is a little bit wonky, but is based on pretty good social science about the last dig-outs from some of the big recessions. 82, 83 is a good snapshot for us. There's going to get a tipping point where if the economy continues, and I call this a real high-class problem, this is better than the opposite, right? It's better than 25% unemployment like Spain. It's better than what's happening in France and to a certain extent in Italy. Certainly better than Greece. So I'd rather have this problem than those problems, but this will stress your role out. And that is, we have about 40 million suppressed quits since 2009. If you ask the question, how many quits didn't happen that would have happened in the normal course of events, it was about 40 million. We lost 40 million quits. What's that mean? Well, it means that there's a 29-year-old who's holding the job of someone who's typically 22 to 25, but their parents said, you may not move in with us like your sister, so don't even think about it, right? When he had the conversation, he said, well, I'm thinking about moving back to Des Moines, but I need to live with you for a little while I search for a job. So he couldn't do that, so he's still working at that job. The moment he's no longer scared, he quits. Multiply that by 5, 10, 15, 20 million people in a short period of time, and here's what happens. So the quits for the solidly employed, I mean, we are all so happy to have that 29-year-old working in a job that he has 6 years experience for, and the job only requires 2, and he's just like knocking it out of the park. But we dread the day he leaves, right? We know it's going to happen any moment. When the solidly employed start to leave, and they kind of all start to leave at the same time, and we have a theory that the Gen Y cohort will really do it en masse, right, because of the social network communication. So suddenly your friends all start leaving their job, and you say to yourself, hey, I can do this too. I can go take that job. And so we think it'll move faster than it has in past generations. But as soon as they quit, from the strong firms, those strong firms, they can hire better, they have better infrastructure, they have better salary capacity, they can they can give signing bonuses. They start pulling from the mid-firms. And they literally are this giant sucking sound that pulls tens of millions of jobs out of those mid-level firms, and it creates this massive cascade. So you end up with this frenzy of people, and it's a good story for the worker, right? I mean, this is a good story about the economy, unless it goes too far. But in that frenzy, no one wants to give you room to pay attention to I-9 compliance. That's kind of the truth. We've seen it before. I think we'll see it again. We've climbed out of an early 90s recession. We climbed out of a single quarter blip in 2002. Each time we saw in that window, so far as we can tell, the 90s is anecdotal, the 2002 is a light data set. People just don't pay attention when you're overwhelmed with other things. And it makes sense. I'm not blaming anybody. What are you going to get fired for? Not hiring the people you're supposed to hire? Or not doing a perfect job on the piece of paper that your superiors don't even know what it is, right? So it's perfectly rational, and I don't think we should cast any blame, except I want to give you tools to fight back a little bit. So how do we know how many I-9s there should be, and how do we think about them, and where's this liability thing that I described earlier come from? So job openings and labor turnover survey. the best data set the government produces. It's a wonderful thing. You should spend time looking at it. Or just let me summarize it for you. It's the estimation of annual openings and hires in the US workforce on an annual basis. It is collected weekly. It is audited monthly. It's compiled quarterly. It's re-audited on the half year. And there's a deep dive audit done by the same people who are normally doing the census stuff on an annual basis. Great data set, very reliable. Okay, so the numbers using JOLTS data. Let's talk about history. JOLTS, why do I care about JOLTS? Because it is the number for I-9s. Every new hire, right, should have an I-9. So it's the only number in the data, or in the government data system, that equals the number of I-9. So it's actually a very convenient number for our purposes. So estimated annual new hire trend of about 60 million, just shy, per year from 1988 to 2000, give or take. That's 715.5 million hires. Realize the majority of this is happening from turnover. We have a highly, less so in the last few years, mainly because of real estate issues, but we have a highly mobile workforce, and that's a great thing for the country. And that means, though, that people are getting hired and quitting and getting fired and moving around. Plus, we have another confirmed 718.4 million through the end of 2011. I am waiting in the next couple of weeks for the 2012 final JOLTS data audit, in which case I'll add those numbers. 2012 was higher. It was more data, more numbers. So 1.433 billion hires and alleged, reputed, expected I-9s from 1988 to the end of 2011. And that 1.433, just a side note, it's silly when people have like big data number analysis and this kind of pretty good data but not perfect data, when they like have bunches of numbers past the decimal point. The confidence interval of that is about 1.43 maybe on a good day, but just a side note. So you take the 1.434 billion I-9s, and what do we know about I-9s? How well are they done? How often are they completed? How often are they lost? How often are they destroyed? Of the ones that are completed, do they get purged when they're supposed to? So we actually have some pretty good data, and I have Logix to thank for that because they've done analysis at an aggregate level. Plus, I've interviewed lots of different general counsels. It's a funny question. You talk to the general counsel, and they're like, yeah, I don't know about that. You get bumped to VP of HR. No, I don't know about that. You get bumped. Finally, someone's like, I-9s, yeah, I'm in charge of I-9s. I'm like, oh, great. Do you have a purge policy? Like, I've heard of that. No, we don't purge anything, right? So like the how much purging is going on, that's an easy one to solve. And the rest of it we've kind of gathered over time. So this is the hardest one to know, the missing that were never there. About 1/4, we think, of all I-9s were never created. And they should have been. But guess what? They were eligible for purging. And so if you were never caught, it's like the total lucky missing because you didn't create it, but you could have purged it, and now it looks like it's purged. You're off the hook. So there you are. Okay, that's good. That's the happy story, right? So 1 out of 4, you dodged the bullet. No one ever knows. Maybe they congratulate you for purging a little. Okay, another about 1 out of 4, this one we have better information, have been purged correctly and deliberately, and it's very hit or miss. So companies that are in the Fortune 1000, they either do or they don't purge, and if they're purging pretty well, and if they don't, it just never occurred to them because they've got I-9 scattered all over the place, it's just too hard to do. So about 1 out of 4 have been purged correctly and deliberately. We call that the free lunch. Good for you. Get rid of all that liability ticking away inside your shelves. And then that leaves 688.3 million, in theory, I-9s in place, unpurged, even if they're eligible to be purged. So another category of this is the remaining free lunch, right? It's like, please go in there and purge the remaining I-9s that you can get rid of, but it's hard to know which ones those are, of course. So out of those, what happens? Well, a very optimistic substantive error rate of about 35, 36%. When I say very, I mean very optimistic. So this is a select group of big companies that have high-functioning HR departments who affirmatively wanted to figure out how well they're doing and invested the money to do it. You can guess that they're probably doing better than the average company, but that's the only data I have. So 35.5, we will magically assume that that's the error rate for everybody. Haha. Okay. Fines, for now, they go up a lot, right? But for now, if the bill doesn't pass or passes with old fines, you have, a certain amount of kind of fines that are not about criminal violations or pattern and practice or knowing hires, so they're the low numbers. Then you have internal costs, and this is the part that people forget, but this is what you bear. You have time, staffing, counsel. You have external costs. If you have an audit, even just a little audit, you're probably going to retain outside counsel. It isn't exactly cheap, and it's a little bit disturbing. If the auditors get involved, right, then the numbers really start getting racked up pretty quickly. And then, of course, you have PR management if you happen to be in an industry that is exposed or people are going to talk about it. So it's about $360,000 per incident of audit, which, there are some numbers that are many times that size. There are several that are a tiny fraction. Sometimes it's a spot audit. It's actually driven by an investigation. They want to look at so-and-so, and they find a single error. No one takes action on it. You have a brief heart attack for the day. Everyone goes away. Nothing bad happens. We'll call that, $5,000 for your brush with death or something bad for your health. So model shows that the resulting estimated per I-9 violation cost is upwards of $1,300. That's just taking the number of I-9s typically impacted, dividing it into the total incident cost. It's not a great number, but it's kind of the only way to manipulate this. So what do? Well, you add it up. You have the I-9s that are in place. You have the substantive error rate. You ignore all the other errors, including the missing I-9s. We just haven't been able to figure out the model that fairly treats the missing I-9s. But once we do, it obviously gets more dramatic. Average estimated violation cost, we told you what that was. And then the undiscovered liability, if we were a Visa commercial, it would say priceless, right? But it's not. It is instead still priceless, okay. $317 billion. That's a lot of money, right? You add a few more zeros, and suddenly you're talking real money. Yeah, that's right. Yeah, don't show this to Treasury. They'll be like, excellent, right? Yeah, maybe we should collect those. So what? So here's the most basic. So this first part, that's a wonderful academic presentation. Your job is to say, well, that's nice, but who cares? I'm sure there's lots of other interesting numbers that no one ever acts on. Well, let's pare it down to players in the economy that are more likely than not to be held more accountable, fair or not, for a variety of actions, including because they're large or they're publicly traded companies, or maybe they have publicly issued debt, even if they're not publicly traded. Maybe they have joint ventures. They might have covenants with banks. We'll talk all about that. But there's a cohort of companies. Let's call it, the top half of the largest employers, 18,500, who it probably matters more. So they account for a little more than half of all those I-9s at 18,500, which means that if the error rate is equal across all of them, it's an assumption. It probably isn't true. It's probably worse for some, better for some. It's about $160 billion of liability. That's an average of $8.6 billion, or $8.6 million of liability for each of those companies. But if you just take the largest, I was trying to get to a Fortune 2000 cutoff. If you take the largest 1,927 firms, it's the demarcation in the Bureau of Labor Statistics employer numbers. That's why it's that funny number. The average liability at that level of firm is about $27 million, which for some of these firms will not be material, right? $27 million isn't going to be material for Google. It's not going to be material for General Electric. But for a lot of those firms, it would be material because it's a fraction of earned income. And earned income, depending on how well the firm's doing, may be small, large, or negative. So what does this have to do with securities and compliance and litigation? So first, as an employee of a company charged with a function or a duty, not even being a director, you have a fiduciary duty to act in the best interest of your company. You have a basic duty of loyalty that varies in a variety of ways depending where you work, what state you're in. But you probably, absent a few weird caveats, have a duty to know things that are relevant to your job, to report them if they are material for your function, not for the whole company, but for your function, and mitigate them if you can, if they're an ongoing nuisance and or risk of damage to the company. I-9s fit this definition in every possible way. There's just no way to look at it differently. Then you have Section 404 Sarbanes-Oxley, and you have whistleblowers Dodd-Frank. So Sarbanes-Oxley is this huge intrusion at the federal level into publicly traded companies. People forget, but publicly traded companies are mainly governed by state law. So corporate law is state law. Now, mind you, most of it's Delaware law, but Sarbanes-Oxley is one of several kind of plays by the federal government that inserts itself into the publicly traded corporation. And the certifications in Section 404, those are separate things. CEOs and CFOs now have to sign certain things. But Section 404 is about financial controls and process analysis. And we kind of heard today that it's not really on the auditor's list, but it probably should be, and eventually it will be. FCPA wasn't on their list either before 2001. It just wasn't. So, it takes time. Whistleblower, I mentioned, because Dodd-Frank has lots of whistleblowing provisions, as does the new Senate bill. Whistleblowing is kind of the new low-cost enforcement strategy, right? right? You get other people to start the process rolling, and it's gaining momentum. We have lots of history in the United States, including key tam prosecutions and all sorts of stuff where people get a little piece of something that they uncover that's wrongdoing, and the infrastructure, as far as plaintiffs' lawyers are concerned, is actually quite robust. So we haven't seen them yet, but we will eventually probably see commercials that say, do you know if your employer has, and I'll list a bunch of things, bad acts that are subject to Dodd-Frank whistleblowing, and eventually I-9s will be one of them, right? We can feel good or bad or disgusted or whatever about this, but it's a very definitive pattern in US law. And by and large, we are a very low corruption society. We have a very good functioning rule of law. So we got to be doing something right. Maybe some pieces of it have to be a little icky and ugly, but it's definitely there. The markets are definitely stuck in a highly sensitive phase. Yes, we've been experiencing this happy up and up for a while, but the markets are highly responsive as compared to history to bits of news about a given company. So CEO has an affair. CFO gets fired from a board that they sat on that's unrelated. A particular supplier has an issue. These things actually move stock prices more than they used to. Maybe that time will go away, but there's so much noise in the market right now that you get a lot of mobility or volatility from small things. I-9 is a small thing for most companies. It's a small thing, but small things are moving stock prices now, and that's relevant to securities litigation. If a stock price moves because something comes out and the company should have disclosed it and they didn't, there's a cause of action there. So reasonable parallels are also found in things called Wells notices. So a Wells notice is something that the SEC issues, and they say, hey, this isn't really formal yet, but we're looking into this and we think you did something wrong, but we're not sure. We're just giving you a heads up. This is a real quandary for lots of companies because they don't know if they should disclose it or shouldn't disclose it. So they talk with counsel, they talk to their auditors, they do a lot of discussing about whether or not to disclose, in the securities filings, whether or not they have a Wells notice. Sometimes they do, sometimes they don't. What's notable is that no one, to my knowledge, I'm curious if you have seen this, has that same discussion around notices of intent to inspect or other audit activity. The discussion should happen. In the world of corporate governance, one of the best protective measures is process. Do something. Do it consistently. Get counsel, get third-party advice, have a discussion, make a decision about what you do and don't do, and then stick to it. Doing this gets rid of 90% of the problems. But what's funny about I-9s is that it doesn't go through that process. It never gets escalated up. No one reports it to internal audit. The CFOs never know about it. The general counsel tends not to chat about it. It's a very glaring absence, and it is a little like Wells notices, because you will reasonably say to me, Dan, a lot of this I-9 stuff, I know we all think it's serious, but it's a drop in the bucket. It's just like the rest of their industry. It's not a big deal. I don't disagree, but the fact that no one in a position to make those kinds of judgments within the organization for securities filing purposes has that discussion is the omission, right? If the discussion was 5 minutes and your general counsel talking to their outside counsel for securities issues had a discussion and said, yeah, we don't need to file this, you're done. Good day, excellent, all done, right? You are much better off as compared to those who don't talk about it, never came forward, and then they have some little thing that gets blown out of proportion because some community newspaper just decides to make a huge big deal about it, and it gets picked up on social media and you end up with protesters in front, and your stock gets a little hit. That's an unfair day. It's not fair, it's not just, but then if you hadn't had the process of saying we aren't going to disclose this and we thought about it, then you're stuck. Right? You're gonna actually have probably federal class action litigation over this, and it's gonna take up some time. And then finally, and this is the most important point, there's been an uptick in security class actions, right, that cite I-9s, but it's because of extraordinary acts. So Chipotle, American Apparel, and sometimes it gets thrown in with the kitchen sink. So there's about a half a dozen significant, class actions that involve I-9s one way or another. But much more interesting is I used to get a call. The first call was about 3.5 years ago. And then I got maybe 2 calls a year and a half ago. In the last year, I've probably gotten about a dozen calls from people who don't tell me this, but I'm looking them up as I'm talking to them. They're either short investors, or they're hedge funds, or they're both. And why do they care about this? Because the markets aren't really pricing this in, and they are desperately looking for a way to figure out how to link the whistleblower to a bad act, to something that explodes onto the scene, because hedge funds have made a lot of money on FCPA disclosure investigations and stuff that hurt stock prices, and so they're looking for the next thing, because the markets are now pretty responsive to the FCPA thing, and so from a financial economist viewpoint, it's no longer inefficient, and since it moves fast enough, it's hard to make money on FCPA surprises. people think you can make money on I-9 surprises. I don't know of anyone who's made that bet yet, but the fact that they're interested in this is intriguing and a little scary, right? It means that eventually someone will make a run at it. So if you don't know about this practice in kind of small and mid-cap stocks, there are funds who have, you know, $20 million, $50 million, $200 million under management. They have maybe 2 or 3 staffers, and all that they do is they go around looking for embarrassing problems with senior executives, hopefully CEOs, at small and medium-sized publicly traded companies, and then they gather all this extraordinary evidence, and then they short the stock and they publicly announce it. They're actually sometimes liable under a concept called spotlight theory, which says that, you know, though there's free speech and you can comment on anything that's in public, if you spotlight someone's kind of less than admirable acts in a way that they wouldn't have otherwise been public, you might be liable. It's a little like defamation, but different, because it's true. That's the ultimate defense, right? But the fact that that is successful, eventually there will be people paying attention to this. So I mentioned that. I think it will happen in the future soon. So when did it really start? So here's a question for you. We have employment-related compliance laws, lots of them, regulations, frameworks. So when did the first kind of employment-related stuff really kick into high gear? Anybody know? 70s? Yeah. So 60s first, because we had, you know, Title VII. But then you really saw promulgation of regulations by the late 60s and early 70s, but we really didn't like lose sleep over it as corporate players until the 1990s. Nothing big had happened. Now there were some technical changes. Damages were allowed in certain circumstances that hadn't been allowed before. But so it took a good 30 years for it to develop into something serious, and now it's actually quite mature, right? We see class actions, we see individual actions, we have lots of training, all sorts of things. FCPA. So when did FCPA, I think you now know the answer because it was given away earlier today. So when did FCPA come into effect? 70s, yes, I tried to be general, but you're absolutely right, Lon. So 1976 it's passed, 77 it's, you know, becomes actual regs, and really it wasn't until the 2000s that anybody paid it any mind at all, right? Just none. It was considered a complete backwater, and if you knew what FCPA was, you were never going to make partner at your law firm. Now those guys are minting cash, and they get all the big bonuses, and they get to pick who becomes partner. So I-9 workplace compliance laws, regulations, and frameworks. So when did those come into play? The 80s, right? And so we're kind of due, barely. Like it's early. Maybe it's the late teens. I don't know. But if you follow the traditional pattern, because it's a pattern, and it takes, first you have a law, no one understands it, then you have an agency, they promulgate regs which no one understands, then you might have some litigation that bounces around and decides whether or not this actually survive. Then after it survives, then you have infrastructure that arises. So if you have plaintiff's enforcement capacity, the plaintiff's bar's got to learn how to deal with this stuff. That takes a few years. If you have regulatory enforcement capacity, you've got to develop an investigatory arm or start reassigning people. So all these things take time. And all of these things have been happening in the I-9 space. It just takes time. And we're entering the phase of alternative non-government actors. That's the phase that we're entering. It tends to be the last phase because there's got to be enough money at stake. There's got to be clear causes of action. And the plaintiff's bar and other players have to understand what's going on. And that's just started to happen. But once that happens, then it becomes more mature. So weirdly, I-9s and compliance hit 8 of the 9 kind of things we say, if you want to lose sleep, here are the people who show up to help you lose sleep. So federal securities suits, so yes, I-9s can be a part of that. State law derivative fiduciary duty suits, absolutely. That's the lowest hanging fruit, by the way, for kind of specific litigation. Creditor suits, no one thinks about this, but I promise you eventually a big enough bondholder who has trouble or a large bank who's offering a large line, if a company stumbles and is already on the border anyway of kind of certain types of solvency, and that bank's just kind of waiting and trying to figure out how to say you've blown your covenants and I need to call this line and try to essentially position themselves better to get more money back from the company, I'm sure if you dig through the material non-compliance covenants in a lot of these loans, you're going to find something that fits the I-9 story. So if an officer knowingly fails to comply on an ongoing basis with a material component of HR, something, there's going to be some line. And the bank is eventually going to show up and say, you've blown this covenant, you owe us $120 million in 7 business days, or we can talk, right? And that hasn't happened yet, but it will. It's happened over FCPA stuff. Employee suits are ERISA suits. Employee suits are a part of this, certainly. Security and Exchange Commission, they've already started that. They are learning their way around this area. Other federal agencies, DOL and DHS, first among them for sure. U.S. Attorney General and DOJ, yes, they show up actually quite a bit. State enforcement agencies also. The only one is foreign governments, and thank goodness we had to not have one of the people be able to show up and harass us, right? So only foreign governments probably don't have a cause of action around issues of I-9s, though I'm sure somebody could stretch and say, you've made their foreign national, uncomfortable or something. But, out of that, so 8 out of the 9 core areas that are a source of litigation and regulatory enforcement problems for big companies. Yikes. It's pretty big. Okay, so let me wrap it up here in just a couple minutes and we'll do questions. So are you watching for the wrong problem? I already mentioned this so I can go quickly. Lawyers learn how to spot issues, right? You're given 100 pages, final exam, you have to spot the 12 issues and write about them. It's a skill, it's a good skill. It's really sorting signal from noise. A lot of professionals, that's what you learn to do. But the funny thing in I-9 is you're probably taught that the signal is the wrong thing, right? So what's the noise and what's the signal? Well, average person who isn't taught how to spot sharks and dolphins in choppy water, they see things everywhere because everything looks like something unless you're trained. Pilots too, novice pilots have much better eyes, they're younger. There's a great game you play if you're a private pilot and you've got younger pilots flying with you. You all pay each other $1 for the planes you don't spot first. Older pilots make great money because you get really good at spotting aircraft. It's just a thing you get trained at even as your eyes fail you. So each of these things is there's too much noise, and they don't know what the signal is. So combine that with this idea that we have a faculty member here named Cliff Nass. He's a psychologist, distraction techniques, fraud techniques, denial. Distractors are things that seem important, and they let you feel about the other things that you're not paying enough attention to. And so in this story, and a complex distractor is something that people keep telling you is important. In this story, undocumented workers are the distractor. Most companies say, after thinking about these things, you know what, I'm just not going to lose sleep about this because we really don't employ anyone who's undocumented. And that's the noise. The undocumented worker for most large companies is the noise. It's the compliance function. It is, and I'm sorry to say, it's the paperwork, or the electronic work, if you're using an electronic system, is the paperwork that's more important than the undocumented immigrant from a pure dollars and cents compliance viewpoint. So one of the problems is that senior VPs and general counsels say, but we don't have any risk of unauthorized employment. We just don't. We employ engineers. And then they move on. And they fall in for what we call the complex distractor, and it's a big mistake. So I'm going to skip the duty overview other than to say, if you want another example other than the FCPA, so at Stanford, starting in 2001, and then again in 2002, then again in 2003, we sponsored research, then we published a white paper, then we published a big paper, and then we held a conference on option backdating. We just didn't call it that yet, right? So we said anomalous grant date, right? We should have come up with something sexier. Later we came up with all these phrases called bullet dodging, option backdating, bend backing, all sorts of, we came up with good words. If only we'd selected sexier words when we spotted this because it was statistically observable, right? If you look at a bunch of option grants, it's really weird if in a month after month, they all landed on the lowest stock price day, right? So we had someone in the graduate school of business do this analysis, and he stumbled on it and said, look at this, option backdating. Everyone you brought this up with said, that's a paperwork thing. It's not a big deal. No one's ever been prosecuted, right? So what happened? Kaboom. I mean, really hit Silicon Valley hard. I suggest it was one of the demises of basic concepts around options, and people still don't like options, but option backdating, we knew about it, we knew who did it, we knew how it worked, we had observed it in the data, we said it was this big liability, no one ever cared until people with handcuffs and guns showed up, right? And then lots of litigation from that, and it's still ongoing. So option backdating also has a lot of this same feel. So, perfect storm, already covered all these things. People get bounties, you've got different paths of it being reported. The SEC seems to care about it. And, important note, the books and records stuff that the SEC enforces, reasonableness standard, not materiality. It doesn't have to be material, it just has to be reasonable, or unreasonable that you didn't engage in sufficient effort to make sure you had orderly books and records. So, different level of proof, it's easier to kind of bring forward. So I'm going to skip the e-discovery other than to say, trust me, once someone decides to tell whether or not you were not paying attention to this, they will be able to tell with remarkable clarity and insight. They will get every email you've ever written about it. They will look at all of your call logs. You will waive, if you're the corporate, you will waive privilege. It's one of the first things you will do, because why? If you don't cooperate, bad things happen. So if it goes to the highest level, you will waive privilege all over the place. So all those things that you have back and forth that you feel are privileged, do not rely on corporate privilege. This is a standard point now. I think we make in almost all security stuff, which is privilege can be waived. The corporate organization is happy to waive it if it means that just throwing a few people under the bus is all that it costs and maybe some fines, and you don't end up being criminally prosecuted as a corporation, which is how Anderson died, right? So if there is a electronic trail, it will be disclosed. Just no one's looking. And we already talked about auditor dodging. That'll be an ugly day when that comes to the fore, when everyone finds out that certain people inside companies said, don't answer that auditor. I don't want you to send that letter. In most states, that's actually a crime. In certain circumstances, it's a felony. Don't do that. And then finally, what to do right now. So treat I-9 and related compliance areas as if they're a critical function. Turns out they are. Engage in internal processes, books and records, policy analysis, just like you would for books and records of FCPA. You should say, I want to be a little bit like FCPA light. Whatever we do there, I want to do some of it for I-9s, just so we're protected. And then finally, get the attention of your CFO, your general counsel, or your audit chair. And then just, you're probably not in denial, that's why you're here, end the denial. I mean, I talk to a lot of general counsels who genuinely say, never, ever will this be an issue for us. It just can't be. And maybe that's true, but the way to be sure, even if it does become an issue, is to have talked about it, done a little bit of process, made some decisions, and put it to bed, and 90% of your problems, even if they do crop up later, are done, right? Because no one will say, you breached your fiduciary duty by not even bothering to pay attention. You might as well have shown up to work drunk, right? Which is the old analogy that we talk about. So we have about 10 minutes, but let's only take 5 or 6. And I'm happy to answer questions. And I don't mean to seem gleeful. I don't want the day when all this happens, but I'd like people to take action before it comes tumbling down on us like a pile of bricks. That's my goal. Any questions? Skepticism is okay too. You can say, I'm an auditor and I just don't think that's going to happen. Oh, okay, now Margaret really is she's a talented skeptic.
A week or so ago, National Public Radio did a big series on Texas and the construction industry. Mm-hmm. And they interviewed a bunch
on
Texas and the construction industry in Texas.
Yes, okay. Yeah.
And they interviewed a bunch of people who amazingly gave interviews and
candid
talked about all sorts of illegality that was going on. And the one thing I'm curious about that relates to your numbers earlier was they mentioned on the show that in the construction industry, because you can't do an I-9 on most of the workers, it wouldn't fly. They'd be fake documents or you'd be lying or whatever. Mm-hmm. Everybody's going to 1099s.
Right.
And even in cases where they know the worker is not supposed to be on a 1099, they're just everybody's a 1099 worker.
Yep.
We also saw that in Arizona when they went to mandatory E-Verify that the job creation rate suddenly got different.
Yep.
And all of a sudden it looked like a lot of people were going to 1099s.
Yeah.
I'm wondering how that factor plays into the numbers that you were throwing out earlier. Are you
Yeah,
taking into account, jobs? Because a 1099 I don't think is counted by the federal government as a job that's been created?
So let me answer the data piece, which is I think a good question. So BLS tries to estimate new self-employment positions as a job. So it's the weakest part of their data, and they try to figure out when someone is taking a job as an independent contractor when they weren't working before, and they try to count that as a hire, even though it's technically a self-hire. So it is in the data. Your second point, though, is probably the more valid one, which calls into question really how many missing I-9s are there, because if you're self-employed and you're a sole proprietor, you don't have to fill out an I-9 for yourself, and absent kind of a conspiracy to commit fraud, the person who's hiring you as an independent contractor, let's pretend for a moment you really are, obviously there's no I-9 obligation. So where does that fall out? I don't think there's very much of that at all in the 18,500 largest companies. I think that's happening, and the NPR story was fascinating, right? Because he said, listen, I have to pay these wages. I can't fill out I-9s. I have to get in place. Otherwise, I don't win the bids, right? I can't win the bids, for these construction projects. And each of those organizations, I think the largest one had a few hundred people, so they weren't small, but a lot of them sounded like teams that had, 5, 10, 15, 20 people. So I think in a way, if 1099ing people and pretending that they're independent contractors or actually having them be independent contractors is successful, you're probably trading one problem for the other, right? So you've got a wage and hour issue, arguably, and then an employment tax issue, maybe. But I guess you've gotten out of the I-9 thing, at least practically. But I don't think it impacts the 50.4% of the 18,500 employers, the very biggest ones.
Okay, thanks. The reason I was really curious about this was in addition to the fact that we're going to mandatory e-verify, and there is a provision in the new bill that tries to reach down and stop people who are contracting out to get out of their e-verify obligation.
Yeah.
But it's pretty fascinating because the NPR story said that basically the IRS isn't doing much to enforce the 1099 issue. So if you lean on the system in terms of mandatory e-verify and I-9s and all that stuff, and you can avoid
then you'll shift it
the problem, it looks to me like it's probably just going to shift over to the 1099 area,
now,
which isn't
what's
being enforced.
funny is the auditors are all over misclassified employees, right? Certainly in the M&A context, right? But that's the lawyers who are flagging that. But the auditors are definitely paying attention to wholesale misclassification, in part because if a company takes advantage, they had an amnesty for a little while where you could report and didn't have to do the treble penalties. So what's interesting about that is, it's a good point. If we get really tough in one area, people might change their behavior, which essentially violates another area that arguably has less enforcement activity. But what's funny is then they'll kind of walk right in, if they're a big company anyway, they'll walk right into their auditors. Because their auditors are much more dogged about the labor employment stuff, just because when it crops up, it tends to, I mean, the misclassification, you have treble damages, you have back pay, you have all sorts of stuff that really adds up quite quickly, and it feels more real, I think, than I-9 issues. But I think it'll be interesting to watch. I hadn't thought about that. This whole shift of other federal agency doesn't do as good of a job. Peggy.
Dan, on your sort of maturation of enforcement, the 30 years, with respect to the I-9 enforcement, it really wasn't enforced. I mean, at all.
Right.
We do have that dichotomy of help wanted, no trespassing, and so really 4 or 5 years max, so many of what we're taught. So it's not surprising that the auditors haven't yet got this on their radar screen. And I'm just curious to know if your other, examples of taking 30 years had such a small amount of enforcement as we've seen in the employer sanctions law.
Yes, tragically, my best labor employment expert, the Deputy General Counsel of HP, has abandoned me. She was here a minute ago, and I would have turned to her and asked her, I think the answer is it is similar. You had very little in the early days practical enforcement around these issues, probably for different reasons. So in the labor employment side, on the employment discrimination side, certainly on the gender basis, it was resistance, it was institutional resistance, right? We had to create whole new institutions in order to enforce this stuff, and they took a long time to authorize, get built up, and get hired. And the pre-existing institutions that had authority to enforce, I mean, it was basically a bunch of older white guys who said, well, this is a joke, I'm not going to bother to show up. And so I think it took a long time. So it's a different reason, but I don't think there was much government action early on. And then for FCPA, I can say that the regulatory agencies, they just never showed up. They had too much stuff on their hands. It just wasn't something they bothered to really do anything with until suddenly they did. So that is very similar. It makes sense. I don't fault the auditors, and I don't fault companies for not paying attention to this. Until 5 years ago, you were completely stark raving mad to say, I think we should invest a lot of money and a lot of time and a lot of people into doing this thing just right. And I think we should straighten out all the pieces of paper in our office, and we should touch up the flecks of paint. I mean, it was along with lots of other things that a perfect company would do, but it was irrelevant. It's no longer irrelevant, I think. Anyway,
I'm Kayal Smusi again. On the statistics that you gave, the numbers that you gave in the beginning, that was national overall gross.
That's all,
Do you have anything on particular industry sectors or verticals? Could be manufacturing, could be agriculture, could be whatever it is, where I-9 compliance is a lot more than the others. So I have a business idea.
Sure. So two things. One, they're not really costs, and this is relevant to point out, right? It's a big number that no one seems to be collecting on at the moment. So this is important. It's not a cost, because the cost of compliance is actually quite high. I think Margaret asked that question earlier. What have we gotten for all this time and effort? So it's not quite a cost, but in terms of industry breakdown, so potential liability, there is some work out there for the industry breakdown, but I haven't done it. It's actually a little bit harder to do than you would think, although two things. In certain industries, the turnover rates are higher, so that's, that helps inform where the kind of allocation of these I-9s is going to be. And then the second point, and the BLS data actually breaks down like, non-farm, farm, manufacturing, Midwest manufacturing, so you can drill way down. But on top of that, there are certain categories of companies that have more exposure to the unlawful employment, right, the unauthorized employment. But I must say, again, That's the complex distractor. Yes, I guess that company, if they are manufacturing in the Midwest and 10% of their workforce actually is completely unauthorized and they know it and they're persisting in that, they will face greater consequences. But on average, it's not a part of this story. It is a distraction from the fact that doing bad paperwork is what gets you in trouble in this story. So in that sense, I don't have much beyond that.